All right, I would like to welcome you to the Future of Judicial Selection in Iowa, presented by the Iowa Lawyers Chapter of the Federalist Society. My name is Adam Gregg, and I'm a vice president of our local chapter. Before introducing our moderator, allow me to tell you just a little bit about our chapter. It was founded in 2009 to foster discussion about important legal topics facing this state and this country. Since that time, we've hosted events on a wide range of topics, from the rights of detainees at Guantanamo Bay to the proper role of judicial retention elections. If you're interested in learning more, please feel free to contact me after the event. With that, I'll turn it over to Kay Henderson, who's serving as our moderator this evening. She's a news director for Radio Iowa. She's a featured reporter and commentator on the Iowa Public Television show Iowa Press. And she's a recipient of the Shelley Award, which is the highest award of the Iowa Broadcast News Association in recognition of outstanding contributions to the cause of professional broadcast journalism. Thank you, Kay, and I'll turn it over to you.
No need for that, kids. To be honest, the Shelley Award is given because I'm old. We have a distinguished panel, and we have one person that we hope is able to join us in a little bit. But I thought I would just let them introduce themselves to you. So we'll start at the far end with Mr. Cook.
Good afternoon, everyone. My
You
name
want to use the microphone?
Oh, I'm sorry.
That's okay.
Good afternoon, everyone. My name is Guy Cook. I'm a trial lawyer. I've been practicing law about 30 years, and my office is right across the street. And I'm a member of the Judicial Nominating Commission.
Next to you is...
Hi, I'm Representative Kurt Swaim. I'm ranking member on Judiciary Committee and have a small town practice in Bloomfield, Iowa.
Rock Chalk Jayhawk.
That's me. I'm a University of Kansas Rock Chalk Jayhawk person. My name's Stephen Ware. I'm a law professor at KU, and I have been researching and writing on judicial selection since the 1990s, especially in the last few years. I've done a lot of research and writing and speaking around the country on how judges are selected and judicial retention as well as initial selection. So it's sort of interesting to me to be in Iowa where judicial selection and retention are such current topics of discussion. I'm happy to be with you all. Thank you.
We will be getting to your questions, but first the panel has a few moments to share their thoughts on this general topic. And Professor, you seem to be flipping through some notes there, but if you could share with us the significance of what happened in November and your thoughts on how it relates to what has been percolating in other states around the country.
Thank you. Yeah, I'll start by saying I'm not a fan of what happened in November. When you talk about judges who are already on the court, whether judge stays on the court or is removed from the court, that to me is very much the issue of judicial independence. And judicial independence is commonly juxtaposed or contrasted with judicial accountability, making judges accountable to the public. And if you could array all the different possible systems from life tenure at one end to a very accountable system at the other end, I personally lean towards the judicial independence side of the continuum. I like judges to be secure in their jobs for reasons that we can go into if you want. But I do think the Iowa retention election, which was really very eye-opening, startling event for somebody who follows retention elections where they're used around the country. I mean, many of us have enough gray hair to remember Rose Bird and some other California Supreme Court justices 30 or so years ago losing retention. In Tennessee, Justice Penny White. But then really these three Iowa justices losing the retention vote, it's really a very rare, startling event. Retention elections nationwide for judges something like 98% retention rate. In other words, it's very, very unusual to have this 3 judges lose retention. And as I say, I'm generally displeased with a system that does that. But I do think it's too easy for lawyers, especially, to say, oh, well, the problem is with the people who voted out the justices. I think it's important for lawyers especially to do the hard step of, doesn't this say something is broken in the way we initially select judges in Iowa and other states that use the Missouri plan? Missouri plan is the term I much prefer to merit selection. I think merit selection is a biased term in favor of what I will call a nominating commission system or a Missouri plan system. Seems to me that when you have a Missouri plan system where the bar has so much power in the initial selection of judges, because the bar gets to select members of the nominating commission, that the non-retention of 3 Supreme Court justices is a real signal that there needs to be a more democratic and more open process for initial selection of judges. I can go on about that longer, but I shouldn't take more than my allotted time, so I'll stop there.
We have our 4th panelist who's just arrived. He gives his apologies. He'll introduce himself briefly to you. He's a member of the bar. If you want to use your microphone there.
Looks like we're on. Thank you. Sorry for being delayed. I'm State Representative Chris Hagenow from Windsor Heights, representing also part of the west suburbs of Des Moines, Clive, and part of West Des Moines. But I was in a committee meeting. It ran long tonight and trying to scramble to get over here. So, yeah, I have an interest in this. We all do. We're all here and just trying to learn and figure out, if there's a path forward that can maybe restore the public's confidence in the system while still getting us the best possible outcomes for both the bar and the public, and for the system at large. So, I think like you, I'm still trying to figure out exactly what that is. So, I don't know if there's anything else you wanted from me by way of introductions. I have no prepared comments.
Okay.
Thank you.
Professor Ware just mentioned that this was perhaps a chance to have a process of selecting the justices that is more open and transparent. Mr. Cook, you were involved in that process this time around. You did take some steps. Do you think there are more steps that need to be taken to restore public confidence in the process of selecting judges in the first place?
Well, let me say this. Reasonable people can disagree, and with all due respect to Professor Ware, I don't believe that the retention vote, as historic as it was, exposed some flaw in the nomination process. It certainly shined a light on it, but this process we've had in place for some 50 years has produced a lot of fine judges over the years, and so there's really no linkage, in my view, between the retention vote and the nomination process. Nevertheless, there's a perception that there is, and it certainly put more light on the process. And it was, I think, a positive development, at least to the extent that perception is reality, that we opened the process and had the public a chance to see the workings of the commission, see the quality of the applicants, and see the careful work that the commissioners were doing. I would tell you, just as a byproduct, having been a member in this process when it was closed and when it was open, the candidates were far more better prepared and polished. And it sounds a little crass to say this, but even some of the non-serious candidates looked pretty good because they had done their homework and they'd worked pretty hard to put together a presentation, and they knew more than just the 15 people were watching. And so it's a positive thing. I think any time that you can have transparency in the process and open the process, it gives greater confidence, and people are always fearful of things they don't know, and if they see it for themselves, they can make their own judgments.
Representative Swaim, the professor said it was a startling result. You were out on the campaign trail. Number one, were you startled by what happened? I would assume not, since you were out among the public. And number two, what are your thoughts in regards to what the legislative response is going to be? What's the appetite in the legislature for responding to what happened in November in terms of policy?
Well, I think just speaking to the attitude toward the public, it was pretty much kick out the bums philosophy, and so it was just a bad time to be on the ballot. There were a lot of factors that coalesced, I guess, to bring that about. And so I think that it would be unfortunate if we read too much into the past election, in my estimation. I share the comments about the importance of the independence of the judiciary, and I believe in my heart that that commitment to the independence of the judiciary is strongly embedded in the legislature. And so in that regard, I think that we would move with some skepticism from a system that the majority of the legislators, and I think the majority of Iowans feel overall has served us well.
So you're talking about both selection and the retention. You don't see any change in...
Well, to say no change might be overbroad, but just like Guy said, I mean, I think the opening up of the process is a good thing. I think that I think that there's some things that we can take a look at, but I'd be surprised if there were anything major happening in this legislative session.
Representative Hagenow, sort of the same question to you. You were out among voters. You were sort of getting a read on what the mood was in regards to these justices. And also, just to move the conversation in a slightly different direction, did you find it odd that the pro-justice folks were sort of engaged in sort of an eat your spinach campaign, in that this is such a wonderful process that shouldn't be monkeyed with? I mean, did you find that unusual?
Yes. I'll start by way of maybe an anecdotal story about mood of the voters. And
We love those.
Yeah, I know you do. But no, I found I was out doing my campaign door knocking, and this was probably 2 or 3 weeks out from the election. And I'm constantly reminded at how much the average person on the street is paying attention. Sometimes we have this maybe an unfounded assumption that voters really don't know the issues that we deal with. And I ran across a guy in Clive who was not of the same party I was, and I think in any other year would have probably wanted to talk about, whatever. And he said, well, what do you think about this judicial retention thing? And he wasn't really fired up about Varnum, and he wasn't really a throw the bums out guy, but he was really thinking about it. And he was really engaged in what his response ought to be. He said, I'm thinking about voting no, because I think we need to do something different. And we talked about some of the issues of the day. But he was really wrestling with this. And this was an average, what some people might think, apathetic voter. And so I guess to piggyback on what maybe Representative Swaim said a little bit is that it was an extraordinary year, but the voters were paying attention. And I guess to carry that then further to the second half of your question, I'm not going to judge the messaging on the pro-retention campaign. I certainly, as a politician, I probably would have done it differently if I were advising that side, but I'm sure informed people will disagree on that. But one thing that troubled me with that I think is that there was a sense, both before and after the election, that that somehow the voters of Iowa were fooled, or that they were somehow coerced into something that they shouldn't have done, that there were outside forces and nefarious actors that somehow redirected people's feelings on this. And I guess I have a more, in my experience of being out there among the voters, and maybe just my philosophy of this, is that we ought to be very careful when we think about why people voted, to make those kinds of assertions. I think we ought to start from the assumption that the voters know best. And we ought to listen to the voters when they tell us something. And we can maybe disagree on what that message was, and that's fine. But let's start from the assumption that we have informed voters that are exercising their democratic right responsibly, and that they do have a message they want to send. So I guess I just wanted to say that, and maybe as my own backdrop for how I approach everything.
If I might just give a little anecdotal story on the other side of this. It's just sort of a weird coincidence. One of my clients is, I represent this bar over here called the Blazing Saddle. It's a longtime gay establishment, and I was there doing work, working on a matter for them one day, and stopped in to talk to my client, and there were some people in there. It was shortly before the election, and while I was waiting to talk to the client, I chatted up a couple of fellows there at the bar. What do you think about this vote that's coming up on the judges? And two of them said, we can vote on the judges? Now, this was pretty shocking to me because, and maybe it's a stereotype, but I would have expected that this particular constituency would have been well informed that the election was coming. So I do agree that you should trust the voters, and we should start from the premise that people are smarter than perhaps the cynical view. But it does go back to the history of how some of this process changed, from electing judges to the merits election process. And I did a little research into this even before the vote because I was on the commission and asked to speak. And if you look at the process, you'll see that the Missouri plan, and the professor can talk to this, actually came about as a result of disgust with the elective process and some manipulation of the elective process by Mr. Pendergrass, who was sort of part of the Truman Mafia in Missouri. And that was part of the spark to start this. And then if you contrast it with here in Iowa, and there may be some folks in the room that remember when we changed, but this was actually driven by good government types. The Ripon Society, the League of Women Voters, and part of that constituency had taken the view that people were not informed on judges, that they were voting based on what people's last name, the ethnicity of their last name, or they were easily led around by the dirty unions or the dirty Democrats or some boogeyman that was telling people how to vote. And this was an effort to put the selection process in the hands of people who wouldn't be influenced by those things, but we would be looking for the most qualified. I mean, that's the core of how some of this came about, particularly in Iowa in 1961 and 62.
Professor, you mentioned some votes in other states in regards to judicial retention. Has there been any movement in those other states where judges have been tossed off the bench of seismic proportions? Or is a judge tossed off the bench and then people sort of move on and do something else with their lives?
People move on. So if past is prologue, Iowa voters won't keep kicking out Iowa judges. No guarantees, no warranty. I'm a contract law professor. No warranty on this. But the connection I started to draw a minute ago, and I appreciate the opportunity to finish the connection, is really this, which is, if we look around this room now, I'd love to see a show of hands. Who is not licensed to practice law in the state of Iowa? Raise your hand if you are not licensed to practice law in the state of Iowa. Please, 3 people who've raised your hands, keep them up if you are an Iowa citizen, an Iowa voter. Okay, you 3 are the second-class citizens. When it comes to selecting judges in Iowa, you 3, like 3 million other people in this state, are second-class citizens. Everybody else in this room has a vote that is far more powerful than your vote in selecting lawmakers. Judges make law. When we talk about judicial selection, we're talking about selecting lawmakers. And Iowa, like about 8 other states, has a terribly undemocratic system for selecting these lawmakers. A system that gives lawyers' votes vastly more weight, about 300 times the weight of a non-lawyer's vote. So my challenge to all the folks who didn't raise their hand here, and since I've got tenure, I can say controversial things. I can make challenges. My challenge is, how do you defend that lack of democratic equality? How do you defend that violation of the principle of one person, one vote that gives a member of the bar so much more power than a fellow citizen? It can't be that lawyers' expertise in selecting judges is necessary to a quality judiciary, because states that don't have this democratic deficiency still get lawyers' expertise in the process, and they produce just as high quality judges as the Missouri Plan states. And it can't be that judges don't make law. Judges are just technicians who run a courtroom efficiently, and all the lawmaking is done in the legislative branch, because we lawyers know better than that.
Representative, Representative Swaim, as a barman,
Yeah,
so to speak,
well,
and a legislator.
As a representative who never has tenure, why, I'll respond briefly. I would just kind of reiterate what Guy indicated. The history of this is that if we go to a type of elective process, that was the graft, that was the history of big bosses, that was the history of political influence, not only in Missouri, but Kansas and other areas, which prompted us to go to, I know that this term bothers you, but the merit selection process, because that's what I believe that it is. And if you go on, I dispute the idea that we cannot quantitatively differentiate our judges. Year after year, the Chamber of Commerce, a very conservative group that this group might pay attention to, consistently ranks our judges among the best in the nation. Last year, 4th in the nation. And if you look at the other judges that are selected on the merit selection system, that they traditionally rank higher. It's true also that it's been shown that they have less ethical complaints, and that in terms of the public perception of justice, which we're all concerned about, the study shows consistently that if you have a merit selection, a Missouri-type plan, the public perception of justice is far better than if you have a political-type system.
Representative Hagenow wants in on this, but why are you shaking your head?
Well, I probably ought to defer to the professor on part of this answer, and I will. I think it's important to know that that at least in my mind, and I think this is accurate, the alternative or alternatives to the Missouri Plan, the merit selection system, is not judicial elections. Is that, we're talking about the federal model, or, now, we've got a bill for just about everything in the legislature. If you wait long enough, you can find something that will get your interest piqued. But it's certainly not a direction that I, as a legislator, have any interest in on judicial elections. But I do think there's several other things that we can probably consider. But I just wanted to throw that in and out.
Yeah, thank you. Representative Hagenow made one of the points I was going to make, which is that both of the gentlemen to my left have dissed judicial elections, and I join them in dissing judicial elections. Notice that that's irrelevant to the question, is it better to have a bar-empowering, undemocratic Missouri Plan system, or an appointment process for judges that is democratic, that has popularly elected officials playing the role that the bar now plays, right? As to that question, the bad things about judicial elections are not relevant. Now, the one other point that I wanted to respond to from Representative Swaim is the idea that the judges in Iowa and other Missouri Plan states are more meritorious in the eyes of the Chamber of Commerce or anybody else than, not election states, that's not what we're comparing them to federal model states, to states that use a Senate confirmation system like the U.S. Constitution has. And there, the data simply does not back up the assertion that Missouri plan judges are of a higher quality. The Chamber of Commerce, it loves Delaware. Delaware is a Senate confirmation state.
Mr. Cook?
Well, I guess I'll take up the challenge that the system is skewed by lawyers. Every state that has merit selection is not exactly the same. They all have different modifications and slightly different procedures, and I think Kansas is heavy on the lawyers. Of course, here we have a 15-member commission. 7 are lawyers elected by the lawyers in their congressional districts, and 7 are lay people appointed by the governor. And then the second most senior justice presides over the process. And I think you can make an argument that there ought to be, in the merit selection process, people who might have some expertise on what the good qualifications are for a judge, and people who might have some ownership in the process, who want to see that we pick judges who are qualified, who have high integrity, who have good temperament, and who have the skills that people with courtroom experience or lawyering experience know are essential, because the lawyers don't want a system that's skewed one way or the other. They're never going to know what side they're on. They want judges who are fair and impartial. And when I got invited to this event, I thought, well, this is interesting. I went to my study and I pulled out this book, the Federalist papers that I carried around at the University of Iowa some 35 years ago, and still have. And I read, Madison 51 and Hamilton 76 and Hamilton 78, and what the Founding Fathers were after is the same thing that we're after in the merit selection process we have here, and that's high-quality judges, an independent judiciary, and Hamilton was sort of in favor of a little weaker branch that we'd call the judiciary. But the question is, how do you get to that goal? And I really do think that having some lawyers in the process, not controlling the process, but having input in that process is valuable. One of the things that I've learned being on the commission, and it's a little bit analogous to, I serve on the lawyer grievance commission that disciplines lawyers, and I don't know how long my sentence is, but I'd sure like to get off of that thing. But I learned a thing in that process that we'd have complaints come before the commission, and the lawyers would have a point of view that would be much different than the lay people. For example, the lawyers there might be someone coming before the grievance commission that had violated the advertising rules, and the lawyers would be all over it. And the lay people were like, what's so big about that? They'd have a much different perspective. Or there might be a dispute about whether a lawyer had been diligent in handling an estate. And the lawyers would be, well, you got to cut them some slack, they got these other pressures, and the lay people would be all over it. And so what that illustrates, if you transfer it to the nominating commission, is the lay people look for something different, and the lawyers look for something different. And between that diversity, we have a rich opportunity to find the best qualified, highest integrity, greatest competence and temperament. And you take the lawyers out of the process and you lose what the merit selection is about in part.
Professor?
Mr. Cook describes lawyer involvement in the Missouri plan system as though lawyers are solely concerned with advancing justice, pure heart. And even if that's true, that lawyers have pure heart, lawyers, like other human beings, see the world through their own lenses. And if you've been a plaintiff's trial lawyer for 30 years, doesn't that make your lenses through which you see the world a little different than if you've been counseling businesses for 30 years? Or you've been a criminal defense lawyer, or you've been whatever kind of lawyer. And don't we see within the bar, when it's time to pick members of the commission, politicking going on with different types of lawyers saying, let's get one of our own on the commission. So we definitely don't want to act as though the lawyer side, the bar side of the Missouri plan is apolitical. It's political. It's just a different kind of politics than the Republican-Democrat politics. It's not the politics of the citizenry, it's the politics of the bar. It's a narrow group's politics. And the other point I wanted to respond to is the distinction between having lawyers on the commission and having the bar select the lawyers on the commission. Notice how many of Mr. Cook's arguments were good to have lawyers on the commission, good to have lawyer expertise on the commission. Nobody here is fighting that. It's who gets to pick those lawyers that's the crucial question. Having the bar pick those lawyers is the undemocratic part of the Missouri plan. Many states have lawyers on the commission, and the lawyers are selected by popularly elected officials. That's a democratic system.
Representative Hagenow, you didn't get to respond to this question, and before we move on, and I run out in the audience with a microphone and let people ask questions. What do you think the appetite in the legislature is for making changes in the process?
You know, I had that conversation with several people today, more in my own caucus, but others outside, and there's interest. The legislature has dealt with so many issues that I'm still trying to figure that out. I mean, we're running up against the funnel week too, which is by rule, bills have to leave committee in order to be considered, and that's a week from Friday. So we actually are kind of running towards the end here, but I think there's interest in having a conversation, but whether this thing gets the critical mass that it needs to move to the House floor, I don't know. I'm going to be working to see if we can't at least get some kind of a framework to at least get something survive the funnel and continue the conversation on. But I think that, you know, Representative Swaim's kind of nodding his head. I think he'd probably take a just slightly contrarian perspective on the other side of that. But yeah, I don't know. Do I see as something becoming law this year? No.
Do you, as politicians, you and Representative Swaim, advise the judges and justices who will be on the ballot in 2012 to start raising money now for a campaign?
Well, they might. No, I wouldn't recommend that, but they probably also ought to. I think they're all looking over their shoulder. I think they've seen what happens, and you know, I've heard stories of kind of what they think. But I think the professor made the point a minute ago that. So the steam's been let off the valve, I think, to a large degree on this, and it remains to be seen whether that level of voter frustration exists through to 2012, and I think that's an unanswered question. I don't know the answer to that, but yeah, that's my non-answer for you.
Representative Swaim, have you recommended to Justice Wiggins that he begin raising money?
No, I haven't. But again, with the same caveat that the professor added, I think that the climate will be different in 2 years. I don't anticipate the same factors combining again in 2 years. But this is a difficult thing to predict.
I have one other question, then I'm going to start roaming among you, so have your questions ready. Mr. Cook, Governor Branstad has, over the past 3 weeks, on each morning weekly press conference on Monday, criticized the commission for giving him the name of one woman among the 9. Are you sensitive to the fact that there were a far larger percentage of women who applied than actually wound up in that final list of 9?
Yes, and I can tell you, first of all, that I'm confident that Governor Branstad will pick the best people because we sent him 9 of the best people. So he can only do good. But it's important to put in perspective how the process works. The commission members don't get together and say, okay, we've got to send 1 Democrat, and we've got to send 1 Republican, and we've got to send 1 woman, and we've got to send 1 old judge, and we've got to send 1 young lawyer. It just doesn't work that way. The way that it works is that the people are looking for those candidates who have the highest quality. And it produces what it produces. And in this process, there were 61 applicants, I think 60 that we actually considered, and there were 10 women. And the process is very unique this time because there were 9 openings or 9 slots to fill, and the first 2 or 3 pop out pretty quick. And then they bunch up when you get to the 5, 6, 7, 8, 9 outer ring. And that's where there's a lot of competition, and where people might get 6 votes or 7 votes or not quite over the top. And perhaps it's at that stage maybe that gender becomes an issue when people making decisions, or geography makes a decision. But frankly, I wish that more women had applied, because 10 out of 60 is not representative of our society. And of those 10, not all of them really were serious candidates, I'm sorry to say. They didn't have the qualifications that would put them in the final group of, say, 20. And it would have been nice to have more women to send to the governor, but there were other candidates who got the 8 votes above some of the other women candidates, and that's just the way the chips fell.
Okay, folks, anybody have a question, raise your hand, and I will come running. For those of you who are old, I'm Phil Donahue. For those of you who are young, I'm Oprah.
Regarding what happened last fall, in addition to this maybe having something to do with the selection process for judges, might it also have something to do with feelings voters have about separation of powers? In other words, what checks are there on overreaching by the Supreme Court other than retention elections that can't be accomplished within many years of effort to amend the Constitution? And what about that aspect?
Who wants to swing at that first?
I guess there's always impeachment, but I hope that's not commonly used.
And I wonder if the professor knows the can of worms that he may have opened, given some of the recent conversation here in Iowa on that. But no, I think we have, as I understand it, our Iowa Constitution is, comparatively speaking, difficult to amend. We don't have ballot referendum here. And that was part of the frustration, I think, going into the election, is that you had an unpopular court decision, and the people felt like there really wasn't a recourse that wasn't going to take many, many years. And when you start talking about checks, I mean, you quickly wade into matters that raise significant constitutional questions. And I'm going to specifically punt on those tonight, because I just am. But and I think that's probably further afield than what we came here to talk about tonight. But yeah, I think that goes back to my thoughts just on voter frustration, is that there is a broader conversation that we probably need to have about that. But like I said, it's a big can of worms, no doubt about it.
Representative Swaim, would you like to jump in the can?
I don't really want to, but I did get this perception. I was out on the campaign trail too, and my perception was that people will take quite a lot, but they won't take something rammed down their throat, and that's the perception that they had of Arnhem. And I realize that when we've had landmark decisions before, that there was similar types of backlash. And Brown versus Topeka Board of Education, I mean, it was really before my time, but I've read and I've heard that there was talk about impeachment after that case as well. And so we really come up to the question of judicial independence and the role of the court as guardian of the rights of the people, and having a process. And we do have this process, and Chris, actually it's not that difficult. They had the opportunity for Constitutional Convention, and they voted against that, which is sort of difficult to reconcile. And then we don't require a supermajority. We require a simple majority to change our Constitution. And so, it's, I don't want to, I don't have the answers, but having been on the campaign trail, I mean, it is a fact among the voters that I spoke to that there was a perception that that this had been crammed down their throats, and maybe that's that happens whenever whenever there is probably a major constitutional decision, and so we just have to deal with that as a society, and we'll work our way through it.
We have another question here.
Hi, this question is for Guy Cook. I think I understood you earlier. You indicated that merit in the discussion of merit, that geography sometimes becomes a factor that the commission considers. And I was just wondering, how is geography a question of merit? Is a lawyer from Northwest Iowa more meritorious than a lawyer from Southeast Iowa? Because to me, geography seems like more of a political question rather than a question of the qualifications of a justice. So I'd be interested to learn how those conversations go on the commission.
Well, I think it's a well-established fact that lawyers in Northwest Iowa are much smarter than those in Southeast Iowa. No, I'm just joking. Maybe I wasn't as clear as I should have been in my comments. Geography, gender, those kinds of things really are not part of the merit selection process. But in the final analysis, all candidates being equal, of equal merit, bunched up right together, then some of these minor factors have play. Very, very minor factors, and they're really not the driving force. They're not even the tail of the dog. They're the flea on the tail of the dog. And so maybe I gave it a little too much more importance in my discussion. I can remember a time when we sent out 3 names for the Court of Appeals. They were all men. I think they were all judges. And I got a call from some newspaper editor that said, "What's this all about? Why are they all from this part of the state, and where are the women?" And we had a very cordial discussion about, we looked for the best. These were the best. So if I suggested that the merit that we're looking at is where they're from, I misspoke, and I didn't intend to suggest that. I did want to say something about the question of checks and balances. I think the retention vote is part of that process, and I think there's people that can argue that it was hijacked this time and all that, but I had someone come up to me before the process, before the vote, and say, "Well, has anybody ever been voted out? I mean, if they've never been voted out, why are they on the ballot? Why are they at risk? I mean, why don't they just have the job forever?" And so I think the system has learned something from this process, and I think going forward it'll be different. And I read some things preparing for this, and there's an article in the Litigation magazine, which is a fine magazine by the ABA, summer of 2010. It's volume 36, number 4, and the headline or the title is "In Defense of Judicial Elections, Sort of." And it's a very interesting article written by a fellow who ran for judge and didn't win. And he ultimately concludes that the merit selection is the way to go. But he says some very enlightening things about what judges can learn from politicking a little bit and being on the ballot and getting out there with the regular folk and not attending bar meetings and learning what the public really feels. Not because they will make decisions in that way, but taking temperature and measure of what the voters' attitudes are.
Thank you. This is a very interesting conversation, and I think it was good that some light is shined on this. But my personal feeling is that the message had very little to do with judicial selection and everything to do with democracy and politics, and having something shoved down your throat. And I personally believe this will be a big issue in 2012 if the Senate does not allow a vote on a constitutional amendment, and you can bet that Mike Gronstall will be targeted big time at that time, and there'll be some carryover effect on the judges as a result, no doubt about it. So, I guess I'm concerned that the politicians have not got the message as to what this really was all about, that this was an issue of the people not having a say in things, and I'm just curious as to what you see happening down the road on that score. And I think there's some merit to some changes in judicial selection, although I think everything I ever hear is that everybody wants judicial independence. Everyone wants, we all want kind of the same things, and all we're talking about is tweaking. And yet you hear these statements that, we're going to throw it out and we're just going to do all judicial elections. And I haven't heard anyone in this state say that. We heard the former Alabama Supreme Court judge say that. But, are the elected officials throughout the state going to get the message? And is anything going to change, or are we going to have a continued sense of frustration from the voters out of this?
Go ahead.
Being an untenured representative and a lawyer from Southeast Iowa, I hesitate to respond. But, I think you've hit on something. I mean, I think it was a combination of the Supreme Court decision that was, that the people, surprised the people, plus the response of the legislature. And so, I mean, I think that is a fair question. And, coming from a conservative district, I maybe understand it more than from some others, but I understand the question. I think it's a very good question. The conflict that I have is that I understand very, very, very well that the system has served us well. I mean, there is no doubt in my mind, and I have spoken to those like Guy and those that are on the commission, and it is a very apolitical process in Iowa. I mean, I really believe that it is, that they are searching for the right candidates, and I have spoken to those on the commission at the district court level of all political stripes, and there is a genuine concern in Iowa for to select the best candidate, and they do. I'm convinced of that. They do, and we have a great judiciary, and as a lawyer and as a representative that's concerned for our judicial system, I understand the question that you raise and the problem that it poses when we consistently reiterate the message that we know without trying to appear like we're saying eat your spinach. And that's the challenge that we face as a bar and as lawyers and as politicians.
Representative Hagenow, do you sense that there has been a great awakening among the judiciary, which I think is the crux of his question?
Among the judiciary, I can't, I have no way of knowing. I mean, what's going on in the hearts and the minds of everyone there. I was going to come at it from a different angle, I think, in terms of what voters are sensing. I can see that, one, the voter anger came from, in large part, Varnum. I mean, we all know that, and so that's the tension point, and that reforming the judicial nominating process or any of these other tangential issues aren't going to address that underlying frustration. I mean, I think we all can say that plainly. So, and that goes back to what Representative Swaim said. People don't like having something forced on them. And one theme I've heard from people is, shouldn't the people have ultimate authority of their government? And so here you begin with, you have the Varnum decision. That was a tough pill to swallow for a lot of Iowans. And then you move on, and we couldn't get a marriage amendment passed at all through either chamber after that to remedy that. Again, people feel like they're disenfranchised. Moving forward now this year, now the House has passed the marriage amendment to try and go down that route, but now it's blocked again. And again, people feel disenfranchised. And so, I guess my thought of this, until people again feel like they have the political power over their government, I think this underlying issue persists. And so I think Bill is exactly right on that. And what exact form that takes to restore that feeling of power over everything, that remains to be seen. But that really is the real core issue here.
Mr. Cook, you spent a good deal of time over the course of 1 week inside the Iowa Judicial Building and, let's say, hung out with one of the justices for hours on end. Do you think they get it?
Well, I'm certain they do. These are smart folks, and they've seen a mortar come right into their facility. So they do get it, and I mean, maybe I shouldn't say this, because these are good people that lost their jobs, and at least a couple of them that I was friendly with, and I hated to see them lose their jobs. But it's not the end of Western civilization. It might be for those 3 judges. It's a healthy thing for our process, and we'll be stronger because of it. There is a duty, though, I think, that the lawyers have and the judiciary has, not so much to force people to eat their spinach, but to educate on the civics here. I mean, judges serve the public. They don't represent the public. They're not elected to take care of constituencies. They're there to protect the rule of law. And Chief Justice Cady gave a speech not long ago where he set forth the very moving facts involving a judge in Plymouth County who was involved in essentially a mock hanging because he was protecting the rule of law, and the populace didn't like it. And that's what these judges were doing. And maybe they were ahead of their time a little bit from certain people's perspective. One little anecdote that in talking to people before the election was they would hear independent judiciary, and they would hear those words, but what they would register would be unaccountable judiciary. And so what was really the message that really needed to get out was an impartial judiciary, fair and impartial judiciary that protects the rule of law and doesn't make decisions based upon a popular vote. But they would hear independent and they would hear unaccountable. So the judges understand that the public needs to be educated, and I'm confident that they'll do that.
Professor, from your perch in Kansas, do you think the Iowa judiciary has gotten it?
Well, the perspective I can offer as an outsider to Iowa is how your court's decision on same-sex marriage fits the historical pattern. And here's what I mean. In your state, it's same-sex marriage that was the catalyst, the trigger to kick some judges out in a retention election. In the few other examples it's occurred, it's been also a catalyst. You know, there's a case or two, an issue or two, that is the bumper sticker, right? The easy case to summarize for non-lawyers, for the average voters. Sometimes it's death penalty or other criminal law issues. Sometimes it's school funding. Lots of states, very controversial when Supreme Court of a state tells the legislature how much money to spend on K through 12 public schools. In all of these examples, the Supreme Court decision is to the left politically of the center and the state. That's the pattern. When there's judges kicked out in retention elections, it's because the catalyst decision is more liberal than the center of gravity in the state. We don't see Supreme Courts making more conservative decisions that outrage enough voters to kick out the judges. What does that tell us when we also see the lawyers, the undemocratic part of the initial selection process, the lawyers on nominating commissions tending to be more Democrat, less Republican than the state as a whole? We see that in Missouri, We saw that in Tennessee before they changed their system. We see it in my state of Kansas. I gather you see it here in Iowa, too. If we're going to connect the dots here, it seems to me pretty clear that lawyers having disproportionate power in the initial selection process of judges in Missouri Plan states tends to produce judiciaries that are blind, relatively speaking, to the public controversies that will come from more liberal decisions, not on rule of law questions, not on questions where every judge wants to do the right thing and we don't want the judge to lose his or her job for doing the right thing, but on open questions of law, controversial gray area questions of law where reasonable people can disagree. I think it would have been very healthy for Iowa had there been a dissent, had there been some thoughtful judge writing a different opinion, reaching the opposite outcome. The fact that it's unanimous tells me that the initial selection process is not as open to conservative views as I would like to see.
Okay, got a question right here.
I actually have two questions. The first one for the professor and the second one for Mr. Cook. For the professor, you've talked a lot about one person, one vote, and this not being a very democratic process. I believe there was a lawsuit that essentially argued that same argument, and that was tossed out of federal court. Now, I think that might have something to do with standing and some other issues like that, but if brought by the proper parties, do you think that would go anywhere?
Yeah, this is a terrific question because what it highlights is the distinction between one person, one vote in the layman's understanding of everybody's vote is equal versus the constitutional law meaning of one person, one vote. In other words, the Equal Protection Clause of the 14th Amendment has a one person, one vote rule, but not all violations of one person, one vote in the layperson's sense are unconstitutional. For example, the U.S. Senate, California has 2 Senate seats, Wyoming has 2 Senate seats. That plainly violates one person, one vote. It's also plainly not unconstitutional. So the legal issue is not whether the Missouri plan violates the layperson's understanding of one person, one vote. Of course it does. That's indisputable. The question is whether that violation of democratic equality is unconstitutional.
Second question for Mr. Cook. I watched a lot of the interviews online, and I noticed that most of the candidates were asked about their feelings on the retention election outcome. And I'm wondering, why were the candidates asked about this? What does that have to do with their qualifications to be a judge? And does that help the public perception that this isn't a political type process? And I also, at least in my estimation, seem to think that most of those who expressed displeasure with the process or even just an acknowledgement of a public perception problem with the courts, for the most part, weren't chosen as finalists. What are your comments on that?
Well, I think there were some questions asked by some commission members about the retention vote. I think they primarily came from lay people, and so I'm speculating a little bit as to what they were after, but I think that it was sort of their simplistic way of perhaps seeking some comment on judicial philosophy.
Actually, saw several instances of Justice Wiggins asking that question.
Okay, now that you remind me, I remember that. And I can't speak for why he was asking that question. And it's a little difficult because I'm subject to cross-examination in the sense that I have some ownership of the process, and I was involved in the nominating of the people that came out. But a couple things to keep in mind. First of all, you need 8 votes to come out of the committee. There are 14 people and a justice. So theoretically, there are members of the commission who didn't vote for any of the people who came out, or voted for other candidates who they wanted who came close and didn't come out. So it's a little bit of a misnomer to assume that it's some unanimous vote. And it's again a little difficult to give weight to this statement, but I can assure you that there was no discussion of politics. There was no discussion of someone's political point of view. and everyone was given a fair shake, whether they were in favor of the Varnum decision, against the Varnum decision, thought the retention vote was perverted and taken advantage of, or whether it was part of the process. If those questions were perceived as driving some other analysis, that's not what happened at all. On what you asked the professor, if I might just make a couple comments about that, we of course were sued. The members of the commission were sued, the lawyer members, and I think Mr. Hagenow's firm was local counsel. And I attended the hearing as a defendant and listened to the arguments. And there's actually been 3 rulings on this subject, the Ninth Circuit and 2 district court decisions, and maybe 4th if you count Judge Pratt. And the decisions all fall in this manner. They conclude that this group is a limited function group that does not deprive the franchise of the ordinary voter, that there are safeguards in place, and that ultimately this group merely nominates names that a elected accountable official then decides who goes on the court, and that'd be the governor. And then they cite other examples of limited function groups that might make decisions that affect all voters, like the Board of Regents, who aren't elected, but make decisions that ultimately the governor may approve or object to, or the legislature may take some action.
I found it interesting that the professor brought up the issue of there was no dissent, and it would have been better if there had been. I actually got kind of the same perspective when I was talking to some people. People who, at the age of 18, left high school, and then 9 months later they were on Okinawa fighting in 1945. These were people without college educations, but they were mentioning the phrase equal protection existed for 150 years. It was functioning within law, and now 7 judges have decided that that means same-sex marriage is constitutionally required, and not one of them disagreed. So, and then after that, in my own experience, I went to the Iowa State Bar Association annual meeting. The opening comments were made by Justice Turnus herself. The speech was described to me by some other people as the most condescending and insulting thing they'd ever heard in their lives. She was talking about how the public was being besieged by misinformation from special interest groups, and the whole kind of narrative about how this thing happened. And, excuse me, there was just a general assumption among the public that the decision was made away from their view, without their consent, probably not within the confounds of case law on equal protection. You look at courts like Maryland, which had functionally the same case, and came to exactly the opposite conclusion with a 4-3 decision. And yet here we had a unanimous decision rammed down their throats, and without a vote, it will probably come back in 2012. So is there anything that the courts themselves could do to mitigate this between then? Such as, something maybe a little bit less condescending than simply saying the public is being misinformed and that the bar needs to explain the role of courts.
I'll just say quickly that Maryland has a Senate confirmation system for their Supreme Court.
Representative Hagenow?
Yeah, I want to address that. And I just completely lost my train of thought where I was going with that. So, in my understanding, and I maybe I'm not as well versed as I ought to be, is their own 8th Circuit has ruled on the opposite side of where the Iowa Supreme Court ruled on Varnum, in upholding Nebraska's similar statute. So clearly the body of law, even if you accept that we ought to go this direction, is not clear. So I think I've always wondered that. What within the realm of the judicial retention vote, would that have looked any different if there'd been a dissent, that at least the people could have kind of hung their hat on, that somebody out there is kind of the voice in the wilderness on this a little bit. So that's well taken too. And I think you followed up with the idea of, does the judiciary get this? Are they going to change tone at least, if not course? And I want to give, I think I mentioned this earlier about Justice Cady's speech. that he gave at the State of the Judiciary, and I was there, and I can tell you that parts of that were not well received by many people in that chamber, because part of it, and hey, I'm an attorney, I understand judicial review, and that's a part of the process, but there was an element there that I was being instructed to, and that the people of Iowa were being instructed, that well, you just don't understand yet, and that's the problem. And there should have been, it would have been helpful for some acknowledgement that there is a difference of opinion on this issue, in that informed minds can come to, and clearly have, come to different conclusions on this issue in current American jurisprudence. And so regardless of where you're at on the issue of Varnum, I think we can probably all agree that you could come to a different conclusion on that. So that was my I guess, response to that is, yeah, I think there should be some kind of a tone coming that we understand this is, and I know that Justice Cady did indicate some of that there is a difference of opinion, but his message was that over time you'll see it our way. And I really fundamentally think that's probably not accurate.
Representative Swaim? Oh.
Well, you know, I'm hesitant to disagree with the professor because he's much more qualified than I am, but, you know, going back again to Brown versus Topeka Board of Education, I understand that there was considerable discussion among the bench at that time to make it a unanimous decision. And so, I mean, if that were any type of a precedent, I would think that, you know, when you have the Chief Justice appointed by, you know, former Governor Branstad on the ballot, and also, you know, the justice that writes the opinion being appointed by Governor Branstad that was on the ballot, I mean, I would think that, you know, tradition would say that that having a unanimous decision would be helpful. And in fact, I mean, some of the constituents that I talked to, that was some very conservative constituents that I spoke to in my district, that was a compelling argument for them. That, you know, if this is unanimous decision, that there must be something to it. But that wasn't probably the majority position, but there were some very conservative persons that took note that it was unanimous decision.
But just to be clear, Katie was not on the ballot.
Right, I understand.
Yeah.
But the fact that it was a unanimous decision.
He wrote it, yes.
Right, and that he drafted the opinion, I think by traditional analysis would make it so that it would lend credence to it among the public.
If governors of both parties had appointed judges in a unanimous decision, that would, I think, be a presumption of consensus and legitimacy along the lines Representative Swaim suggests, if the governors were not restricted by a nominating commission that narrows them down to 3 finalists. The average voter may not understand all the nuances of the nominating commission system, but those of us who can connect the dots for the average voter can explain to the average voter, the governor's hands are tied. The governor can't get him or her that he or she really wants on the bench. The governor's hands are tied by the commission. So that the legitimacy function that we want for big social decisions like Brown versus Board of Education, and honestly I'll say this same-sex marriage issue, we may look back on this 30, 40 years from now and say it's our generation's Brown versus Board of Education. I don't rule out that possibility. I have 2 friends in Iowa City who I really feel their pain that they can't get married in most states. We may look back on it and say this is our generation's Brown versus Board of Education. I would sure love to see that legitimacy, that consensus really be there instead of having the nominating commission tying a governor's hands.
On the question of getting the public involved in the selection of the attorneys on the commission, I think the panel's discussion kind of begs the question. Maybe an alternative would be for the attorneys to select the attorneys for the commission, but select them from the legislative members who are attorneys, who are elected by the public.
Live round up there?
I guess you asked me about what legislation we're going to do. I put a bill together that was kind of a kitchen sink approach to a lot of ideas that we'd come up with. And one of them was to, that's a great idea. I guess I'll start off with, but I sound good to you? Yeah. But anyway, one of the ideas was to have some of the legislative leaders serve on the committee. And I think it is to, as the professor has said, to at least put folks that are more accountable to the people or somehow to bridge that gap. And there's probably a counter argument to the idea of having our lawyer legislators serve on the commission. I can't make it right now because I don't know, but anyway, I don't have a well thought out idea on that.
Yeah, well, a couple of remarks. First of all, I must respectfully disagree with my professor friend. The governor's hands are not tied. The governor appoints the lay people. And with respect to the lawyers and contrasting it with perhaps lawyers who might be legislators, the genesis, of course, is to remove politics. That's how we start with the merit selection. And no system is free of politics. But the merit selection is perceived as having less politics than open elections. And so if you went that way, which is an interesting idea, you'd be tending more towards entering politics into the process, which, again, it's a little hard for me to vouch for it without actually producing proof to you, except the people that we've nominated. There was no consideration with respect to politics, and I know there was a fair amount of debate in some blogs and some websites about the makeup of this commission and that they're all dirty Democrats, or nearly all dirty Democrats on the lawyer side, which I think is really an unfair characterization in this sense. Whether someone is registered as a Democrat or independent Republican is not a very good predictor of what their philosophy is or their point of view is. I think you could look at Governor Wray as a Republican. I think he's a Republican. And you could look at Congressman King. He's a Republican also. I don't think they share the same political views on all topics. And the same is true, you could make the same argument with respect to Democrat. You could pick Democrat elected officials and compare them to other Democrats who might have a different point of view. It goes back to what I said when we first started this process. I don't believe that the retention vote exposed a flaw in the nomination process. We've had a lot of good judges come out of the commission over the last 50 years through different administrations, and no one was complaining then. They're only complaining now with the Varnum decision.
We have another question right here.
Well, I think in general, our system works best when we have transparency and accountability in our system, and I certainly think that could apply here too. Transparency so people know what is going on, and most people don't understand the commission. Even some lawyers might not understand the commission. And then also accountability, so when things aren't going the way that people want them to go or they want to have input, they know who to contact and who to hold accountable, whether it's at the ballot box or through an op-ed to the newspaper, whatever it might be. So I think those things are important, and I'm just wondering what kinds of ideas the panel might have to bring some accountability to the process. One thing that was said is the governor does get to appoint some of the commission members. Right now, the governor is looking at appointing 3 justices, and he won't be able to make any of his appointments to the commission until May 1st would be the earliest date they would serve. And so the staggered terms certainly affect the governor's role with respect to the commission itself. He won't be able to appoint 2 until May 1st, and then the terms are staggered after that. But we'd just like to hear from some of the panelists, what are some ideas you have for reforms to bring some accountability and transparency, some good old-fashioned democracy into the process?
Well, and I think some of the things that the commission did of their own volition were very good things for the process, and I think that was great. So the open interviews, I even talked to all kinds of people that otherwise would have no idea that actually tuned in and watched those. And it was a great civics lesson. So, if there was some action on that, I think that's a great thing. I think it's the open records, letting folks see at least the non-confidential parts of the applications. Those are good things. That's transparency, and it boosts the public's confidence. There are ideas that I've had that I've tried to include in some legislation, but to timeline some things out, there was a lot of angst immediately after the election that Governor Culver was going to somehow try and push through replacements, and I think that would have not been constructive. Yeah, I think that people's confidence would have further eroded if they'd have had that. So, trying to maybe put some timelines in place on how things would happen, I think would be helpful. Just some structural pieces that, that I think we could do just to make the system work a little better.
How would you make that timeline? You have a 4-member court now. And if you elongated the time by which the Judicial Nominating Commission does its work, you elongate the time that you have this depleted court in session.
Well, I agree. Point well taken. I think some members of the public probably wouldn't care about that reservation. But no, I think you just would do something that would merely say that the governor, the justices not retained would then somehow you timeline that out so that if a lame duck governor would not be able to make those appointments, that the slate of candidates would come up for a new incoming governor or after the swearing in of the same governor, whatever. It's just somehow, you wouldn't drag this out for 6-12 months, but just make sure that we codify that the Governor Branstad would have actually had the opportunity to make these appointments. So that's all.
Just quickly, the question asked about accountability and transparency, how to increase those things. And terrific answers are found in the wonderful book that Mr. Cook brought here, the Federalist Papers, where Hamilton and Madison are pointing out that if the executive, one human being, has to stand behind his or her nominee, they didn't say her back then, his nominee, to the bench, and then the Senate...
Hamilton 76, I think you're talking about.
The Senate votes in public. It's a recorded vote. So the elected officials, both the executive branch and the legislative branch, stand before the people at the next election and defend their votes. Unlike nominating commission system, where the commissioners' votes are not public. Honestly, I'm a whole lot less interested in the interviews. I want to see the votes. I want to see which commissioners voted for and against which applicants. That's transparency. That's accountability. Most importantly, though, it's the tying the governor's hands. Governor Blunt in Missouri, with a similar system, publicly said, I don't like these 3 finalists the commission has given me. Maybe I won't appoint any of them. Then his advisors pointed out to him, if he doesn't appoint one of them, somebody he disagrees with will appoint one of the 3. And he said, oh, darn, I got to pick the lesser of evils here. That's not an accountable system.
We have just a couple of minutes before 7 o'clock, and we have a couple more questions in the crowd here.
Yeah, thank you. I have a question about the role of the bar in educating the public, and I agree that transparency and accountability are utmost in a democracy. However, I've had the privilege of having rule of law projects around the world, pushing democratic principles, and sometimes parts of the world I go into, I can see that democracy could be the worst form of oppression without the rule of law. And I think it's refreshing to hear the professors say, judges make law. I think we're in a common law system. We're not in a civil law system. And I think we all need to know the ground rules better than most people know. And again, my question is, what's the role of the bar in really getting to these kind of base education questions upon which we can build our discussion?
Who wants to be the spokesperson for the bar?
I just love that point, which is having a more democratic judicial selection process is not an attack on the rule of law. The rule of law is so important to what makes this country great and so many other countries in the world are seeing so much suffering and injustice because they don't have the rule of law as strong as we do here. So I just think that's a tremendously important point. And of course, we as lawyers are in the best position to educate fellow citizens about the importance of the rule of law, of judges deciding a case without regard to are the parties black, white, young, old, male, female, whatever it might be.
Anyone else on the panel?
Well, I would agree with you. I think as attorneys, as lawyers, we have an obligation to talk to our fellow citizens and explain to them how the judiciary works and what the rule of law means. And I think we should take that seriously. I think it's at some level part of the oath we took when we were sworn in.
There's no question. I mean, officers of the court, I think it's part of what's in the oath, and it's in the ethical considerations.
And we should take that seriously. There's no doubt about it.
On the subject of transparency and opening the process, and I've already said it a couple of times, I don't think the Varnum decision or the retention vote exposed a flaw in the system, but it nevertheless has shown light on it, and it's good to have this discussion. I think it's been great that we opened the process. I mean, I made the motion to open the process, and there were some people who didn't want to do it. They felt like they were being pushed into it. But they went along with it, and it was great to have the process open. I must disagree with the professor in terms of the deliberations. The commission works a little bit like a jury does, and so you have to trust the process. And I'm afraid that the process wouldn't work as well if the actual deliberations were made public. People would be inhibited, and they wouldn't express their true feelings in fear that there would be some retribution. And I do think that the lawyers have an obligation to be more careful when these slots come open, and to take the election serious within the bar to ensure that they have people that they can trust representing their particular district.
Yeah, I was not suggesting that the deliberation should be open to the public, only the vote. Just like the U.S. Senate or State Senate, when it votes on judicial nominees, they can deliberate privately. They can talk to each other privately. But ultimately, their final decision goes on the record for the public to hold them accountable.
Well, I have sort of the ultimate final decision here. Our time has come to a close, but I want to give the gentleman just a minute or two to summarize any thoughts that they may wish to leave with the crowd as we all depart. And they may be here for a few more minutes if you have some questions you'd like to ask them individually.
I guess I don't have much in the way of closing comments other than say that I think this is part of a broader public debate that we need to have, and that it's healthy, and about not just judicial nominating, but the role of the courts and how far some of these things. We need to have this public debate, not just as lawyers, but with folks out in the public, and we need to. This is the conversation of the day, and so this is part of that broader conversation, and I think it's a very healthy thing, and it's been, in the subset that is the Judicial Nominating Commission. I had a long talk with Professor Caulfield from Drake last week. It was great. I really enjoyed it. So thanks for having me here and letting me continue that conversation, because I've enjoyed it.
I just appreciate you all letting me talk with you about this topic, and I'd be happy to continue the conversation privately, either here tonight, or if you want to follow up by phone or email, I'd be happy to do that as well. Thank you.
Well, I just want to thank the Federalist for inviting me, and it has been stimulating, and I appreciate and commend you for the debate and the topic. I guess I agree with Chris. I mean, I think the debate is a good thing. I think we'll work our way through this. I think that it's at the bottom, it's an exciting time in Iowa. It's an exciting time because we are seeing democracy work through the process, and Winston Churchill, he said about Americans. He says, Americans, you can always count on Americans to do the right thing eventually, after they've tried everything else. And I think that we'll get through this, and I think that there will be some casualties, and but we will do the right thing eventually, and that's just part of our democratic process, the great society that we live in.
Thanks for inviting me, and it's been very interesting, and sort of reviewing some of the materials before coming here was educational for me. I do think that there's a positive that's come from all of this, the retention vote, the Varnum decision. People have woke up, and it's engaged a greater percentage of the public in their process, and that can only be healthy. And I think it's great, and I think the court, as painful as it has been, in fact, there's a quote in here in this article I held up earlier that says, talking about retention votes, it's something perhaps like a root canal. You feel better when it's over, but you realize there is something positive in that process. It's an opportunity to learn what real people are doing on a daily basis. So this is the ultimate root canal for 3 people, and really difficult on the court and the morale of the court. But it really has, I think, engaged the process, engaged the public, and hopefully engaged lawyers to be more involved in the selection process.
I wanted to jump back in with one last thing. If it hadn't been said or was said before I got here, I want to thank Guy for his service on the commission. That, just from afar, and I had a law partner that applied, that was a long, especially with trying to fill 3 spots in the court, that was a long, laborious, I'm sure tedious process. And even if we want to change some things with the way we do this system, I think we all know that they really do, in their heart, are trying to find the best members for that court. And so I really feel strongly that I just was sitting here that I need to make sure that I state that I do appreciate that service.
Thanks so much.
On behalf of the folks over there, thanks to you for being here tonight.